No humans were harmed or even used in the creation of this program. I created it from a script I wrote using a generative artificial intelligence platform that also displays my personal avatar. I hope you enjoy it. We, as lawyers, hear all the time about an independent judiciary, but what does it mean to have an independent bar? What ethics rules intersect with the idea that all need counsel, including a given moment's unpopular or disfavored class of people? Hello and welcome. My name is Peter Afrasiabi. I am an intellectual property litigator at the law firm of One LLP with offices in Newport Beach and Los Angeles, California. My practice focuses on copyright, right of publicity, trademark, and related privacy torts. I also teach as an adjunct at the University of California Irvine School of Law, where I teach a Ninth Circuit Appeals litigation clinic with my students, as well as an advocacy and persuasion course. I have taught advocacy at the National Institute of Trial Advocacy and taught advocacy to new barristers at Oxford University in England. But keep in mind, all of the views expressed in this video are mine and mine alone, and are not the views of my law firm, the university, or any other academic institution or entity I work with. Today's program is an ethics program. We look at President Trump's executive orders against law firms, and that allows us to explore some fascinating ethics questions that confront the bar. We explore ethics rules and ethics dilemmas for the firms, for the settling firms, and for the government lawyers enforcing them and advocating on behalf of the executive. And we will walk back in history to the Cold War to see some prior episodes of executive attacks on lawyers in that time's fear-laden environment, where fears abounded about communism and revolution was feared. But first, as we explore ethics and an independent bar, let's start by going back a bit further even, to the Founding Fathers, the earliest days of the Republic, when revolution hung in the air as colonialists battled British redcoat troops. But first and briefly, I want to tell you more about the Curious Lawyer series that we have created for you, a true curious lawyer. The Curious Lawyer series is a fun, educational, and entertaining walk down some of the off-the-beaten paths of law, areas that you do not experience in your regular practice day to day, but which are incredibly interesting and informative, and often yield new insights and valuable analogies or metaphors that you can work with in your practice. In this series, we take a variety of interesting issues and intersect them with the law to find fascinating, new, educational, and informative areas of the law to explore and to better educate you about legal areas you may not know. For example, we have done programs on dog law, where you get to think about your favorite furry friend and see how our relationship with dogs intersects the law, from tort to contract law, to even trusts and estate battles over dogs, and, of course, Fourth Amendment cases where there have been warrantless removals of dogs from homes for violating the leash laws. Or you can see the CIA law program, where you will see fascinating legal topics related to the CIA, secrecy, and the Freedom of Information Act, and where you will learn about that famous Hollywood movie line, "I can neither confirm nor deny." You will learn where it came from, and it turns out it was not Hollywood, but you have to watch it to learn who came up with it. We have also looked at whether there's a little sliver of Yellowstone National Park, where, due to a combination of the Sixth Amendment's vicinage requirements and the subsequent federal districts that were created by Congress to sit over the nation, whether that, in fact, has actually yielded a sliver of land in our famed Yellowstone that is free from federal criminal prosecution. Is it a perfect crime zone? Listen to that program and you will find out. And if you want to brush up on the Bill of Rights, we have a 10-part series with 1 hour devoted to each of the first 10 amendments to the Constitution, so that you, at the next cocktail party, can answer when a non-lawyer asks you what one of the amendments is all about. The one thing the Curious Lawyer series is not is boring. This is most definitely not your typical continuing education, which is often technical, difficult, or stressful. So sit back and grab a cocktail if you are so inclined, and let's explore the ethics rules in play in light of President Trump's executive orders related to lawyers and lawyering. And to do this, we start in Boston in 1770 in a story about John Adams. In a nutshell, the Bostonians and British Red troops have a confrontation on the streets. British soldiers kill many Bostonians, and the soldiers are arrested. It's unclear if they intentionally executed innocents or guns went off in confusion.
So where did the arrested soldiers turn to get a legal defense?
Turns out none of the local lawyers would represent them. They, after all, were part of that time's seriously unpopular crowd. So they turned to John Adams, a leading lawyer from a leading family, and of course a founding father in a few short years. Here is what Adams said, as he later recounted in his autobiography. I had no hesitation in answering that counsel ought to be the very last thing that an accused person should want in a free country, and that persons whose lives were at stake ought to have the counsel they preferred, and that every lawyer must hold himself responsible not only to his country, but to the highest and most infallible of all tribunals for the part he should act. John Adams believed even his enemies were owed a fair day in court, within the concept of due process. So in fall 1770, a trial was held, and 6 were acquitted and 2 found guilty. The Adams story is important to the ethics issues because it goes to the core idea that a fair system of justice, where judges and juries decide people's fates, requires lawyers on all sides of an endeavor. Adams was not personally or professionally targeted by the government for his advocacy defending those soldiers and giving them a day in court. From this episode, thus we can say that America has a proud tradition of lawyers representing unpopular people, a tradition that the Founding Fathers embraced. This tradition took root in the Constitution with the guarantee of counsel in criminal cases and has animated the ethics rules we will now unpackage in terms of an independent bar. Let's start with an overview then of where we are going after that little introductory story about John Adams. We will be looking at the current executive orders that have focused on law firms and lawyers, and we will take these executive orders and look at them through the prism of our ethics rules that apply to lawyers and in our duties to our clients. We will address multiple ethics rules, all of which are strands of another ethics issue, which is the role of an independent bar, and what that means from an ethics perspective systemically for us as lawyers. History repeats itself, and this is not the first time lawyers have come under scrutiny. In other words, the experience of John Adams, as positive as that was for representing that time's unpopular, does not trace a linear line through history. This allows us to look at other times in American history where lawyers have faced significant attacks from the executive branch, as well as the judicial branch, and this will bring us to the case of the 20-year saga of Harry Bridges. On this point, I will talk about the experience of Harry Bridges' lawyers and what happened to them, which is a strand in my book. And there you see my plug for my book, Burning Bridges, America's 20-Year Crusade to Deport Labor Leader Harry Bridges. This is in essence a biography of the serial trials that saw a devolution of due process over time in that moment's fear-laden era about communism. One of the strands in that story touches upon what befell the lawyers who represented Harry Bridges, which raised ethics issues at the time for both their representation of their client as well as the government's attacks on them. In turn, we will look at the ethics rules and the risks that are created by the executive orders, as it applies to the idea of being the most diligent lawyer you can for your client, what we sometimes refer to as zealous advocacy principles. And we will look at it from both sides, because it is not just a question of private lawyers and their ethical obligations, but it also applies to government lawyers and their ethical obligations as they enforce the executive orders. This allows us also to look briefly at a whistleblower government lawyer's claims against the government as it relates to ethical issues for Department of Justice lawyers and his claims at least relating to what happened. As we trace all these ethics issues, you will get an overview of important ethics rules that we all must live with. And of course, at the end, we will summarize it all for you again. And we will take these ethics rules and tie them together to develop a better ethics framework for what it means to have an independent bar. An independent bar, of course, is something that we do not discuss a lot in legal circles, our focus almost entirely and constantly being on the role of an independent judiciary. But the other side to that independent judiciary coin is the independent bar. And these ethics rules allow us to explore that issue, as these ethics rules have created a system that holds important the principle of an independent bar. So with that, let's move to the Cold War briefly. We need to start by getting our bearings on the background facts, and you need the general fact background to Harry Bridges and his first trial, so we may delve into weaponized legal systems. Harry Bridges was a longshoreman in San Francisco who came from Australia when he was 18 years old. He spent many years working as a longshoreman in brutal conditions in the San Francisco port. By the time of the Great Depression, there was immense social and economic angst, obviously, and longshoremen started protesting against the brutal labor and wage conditions they worked under. As the labor unions tried to strike deals with management, Harry Bridges, simply a working man, started himself saying that the deals were not fair and were sellout deals between management and labor to enrich management and not really make the working conditions of the longshoremen better. The more he spoke, the more people rallied around his message and voice. He eventually rose as a result of this, out of the working class into a near-political union leader, as he called for better management labor structure. The existing labor leaders rejected him, but the people were behind him. The result of this was a massive vote that was held to determine the future of the longshoremen in San Francisco, and his voice ultimately prevailed, provoking the breakdown in the inside deal between labor and management. Harry Bridges ultimately then called for a general strike, which occurred in 1934, and it was the first one on the West Coast in history. It literally shut down the shipping trade that the longshoremen were critical for. The photographs from this time period are amazing because it shows the streets of San Francisco completely shut down, much like our streets looked during the COVID pandemic for a while. You can see them in my book even. Harry Bridges now had a position of power because the people supported him, but the existing labor and management structures that wanted to control the situation did not simply back down. They pushed for the support of the local police to go and break the strike, which led to what is known as Bloody Thursday, an infamous event where police killed several protesting longshoremen as they tried to break the strike. Some were shot in the back as they were fleeing the police. The police efforts, however, did not work, and ultimately a deal was brokered. The result of the deal was that Harry Bridges and his vision came out as the winner. He was now in charge of the union, and it struck a deal that was favorable to labor. He had in essence broken the old structure. As soon as he rose to prominence, however, the management and labor positions that opposed him decried him as a member of the Communist Party in an attempt to get the benefit of the then existing immigration laws, which made it a deportable offense to be a Communist Party member. Remember, he had arrived at age 18, was here in what was then a lawful immigration state, but he had not received his citizenship. Therefore, if he was a member of the Communist Party under then existing law, he could be deported. A massive conflux of people from private interests to state and federal prosecutors and immigration officials started working together in what is a legitimate conspiracy to find evidence to prove that he was a Communist Party member. They spent massive resources to build a case. The drama of it is in the book, and it boggles the mind. Fake Communist Party membership cards were procured. People on death row were offered a pardon if they would finger him as attending party meetings. They forwarded it to the Immigration and Naturalization Service, specifically the Secretary of Labor, Frances Perkins, the first female cabinet member in history. She and the people in Washington looked at the evidence and realized that it did not really pass muster, and so originally declined to take a case against him. But this public-private partnership continued and eventually put enough pressure on Secretary Perkins by forcing an impeachment proceeding against her that she ultimately relented and allowed a prosecution against Harry Bridges to occur for being a member of the Communist Party. This then led in 1939 to his first of 4 trials over 20 years, which is detailed at length in my book, of course, but is not the subject of today. You just need to know this for background. Secretary Perkins appointed the dean of the Harvard Law School to be the administrative law judge. He was on the short list to go to the Supreme Court, a deeply respected lawyer and dean of Harvard. Over many months and thousands of pages of transcripts, all of which I have read from the National Archives, itself an incredible legal archaeological exploration, he reviewed the evidence and rejected the government's case. The government's main witnesses were perjurers, even lawyers who had run with Al Capone and been convicted with Al Capone, and the case had no legal basis, and so he ultimately denied it in late 1939. At that point in time, after now almost 6 years of constant pursuit, Harry Bridges thought, well, I have won, and they cannot deport me, so end of story, and I will continue running the union and doing what I do. But he was not so lucky. And this is what led to ultimately a second immigration proceeding that eventually went to the United States Supreme Court. That reversed and held the case was a testament to man's intolerance of man. A third criminal trial then was started, where he lost, and again after years of appeals, the Supreme Court took it and again reversed. Then there was a fourth civil denaturalization trial, where he finally won. In those 4 trials over 20 years, one of the subplots looks at his lawyers and what befell them as they represented him. His lawyers were jailed in his case and in other communist deportation cases. His lawyers were attacked for being communists by government prosecutors, even though they were not on trial. The government compiled watch lists of perceived communists helping Harry Bridges, and his lawyers were put on top of the list. The FBI even had a document discussing, in the event of a national emergency, arresting and detaining the lawyers. As you can imagine, the acrimony was intense. Bridges' lawyers charged a government frame-up, and given the volume of perjuring witnesses, they were not off the mark. But government lawyers saw Bridges as an existential threat to America, and so were ruthless in their speech to Bridges' lawyers. Even though Bridges won his criminal trial, his lawyer was imprisoned for 6 months for being too aggressive and tripping ethics lines in the court. So at Bridges' 4th trial, he had Telford Taylor, a Nuremberg prosecutor and famed lawyer. He had to decide to engage in the same aggression and risk ethics rules about candor and demeanor in court, or avoid it. Senator McCarthy questioned whether he was a disloyal American publicly in the New York Times. Taylor took the high road and won, ending the crusade after 20 years. But along the way, lawyers were watched, placed on watch lists, imprisoned for representing communists, and attacked by government lawyers for being disloyal citizens. This period shows executive excesses against lawyers in a fear climate and how led to a collapse of due process. A crusade, as the Supreme Court labeled it. And that is why it is an important stop on our train from John Adams representing the unpopular to today and lawyers representing the unpopular. So with that, let's turn to the 2025 executive orders against lawyers and start our ethics odyssey into them. Let's look now at the first executive order we are focusing on today from March 22, 2025. It says as follows, and it is longer than what we have here, but this is what matters for our ethics exploration. Lawyers and law firms that engage in actions that violate the laws of the United States or rules governing attorney conduct must be efficiently and effectively held accountable. Accountability is especially important when misconduct by lawyers and law firms threatens our national security, homeland security, public safety, or election integrity. The immigration system, where rampant fraud and meritless claims have supplanted the constitutional and lawful bases upon which the President exercises core powers under Article 2 of the United States Constitution, is likewise replete with examples of unscrupulous behavior by attorneys and law firms. For instance, the immigration bar and powerful big law pro bono practices frequently coach clients to conceal their past or lie about their circumstances when asserting their asylum claims, all in an attempt to circumvent immigration policies enacted to protect our national security and deceive the immigration authorities and courts into granting them undeserved relief. Gathering the necessary information to refute these fraudulent claims imposes an enormous burden on the federal government. And this fraud, in turn, undermines the integrity of our immigration laws and the legal profession more broadly. It goes on our next slide as follows. Unfortunately, far too many attorneys and law firms have long ignored these requirements, Rule 11, when litigating against the federal government or in pursuing baseless partisan attacks. To address these concerns, I hereby direct the Attorney General to seek sanctions against attorneys and law firms who engage in frivolous, unreasonable, and vexatious litigation against the United States or in matters before executive departments and agencies of the United States. I further direct that, when the Attorney General determines that conduct by an attorney or law firm in litigation against the federal government warrants seeking sanctions or other disciplinary action, the Attorney General shall, in consultation with any relevant senior executive official, recommend to the President, through the Assistant to the President for Domestic Policy, additional steps that may be taken, including reassessment of security clearances held by the attorney or termination of any federal contract for which the relevant attorney or law firm has been hired to perform services. Now our second one, from March 25th, and this is about Jenner and Block specifically. But it is similar to others that have also identified specific law firms. My administration is committed to addressing the significant risks associated with law firms, particularly so-called big law firms that engage in conduct detrimental to critical American interests. Many firms take actions that threaten public safety and national security, limit constitutional freedoms, degrade the quality of American elections, or undermine bedrock American principles. Moreover, law firms regularly conduct this harmful activity through their powerful pro bono practices, earmarking hundreds of millions of their clients' dollars for destructive causes that often directly or indirectly harm their own clients. Lawyers and law firms that engage in such egregious conduct should not have access to our nation's secrets, nor should such conduct be subsidized by federal taxpayer funds or contracts. Jenner and Block is yet another law firm that has abandoned the profession's highest ideals, condoned partisan lawfare, and abused its pro bono practice to engage in activities that undermine justice and the interests of the United States. For example, Jenner engages in obvious partisan representations to achieve political ends, supports attacks against women and children based on a refusal to accept the biological reality of sex, and backs the obstruction of efforts to prevent illegal aliens from committing horrific crimes and trafficking deadly drugs within our borders. So now, let's discuss the ethics issues we can distill from the orders before we get into the professional ethics rules that are touched by them. First, they pose an economic risk for representing those deemed unfavorable through pro bono practices, including restricting government access that impinges on representation of other clients. This creates an ethics issue for firms as to whether they can and will properly and diligently do their utmost for their clients, when it may mean angering the executive and damaging their entire business. Second, as we saw in both of them, there is a focus on big law and the immigration bar for immigration pro bono work or paid immigration work, among other pro bono issues litigated by the firms. Pro bono work, of course, allows those without money access to the courts, and those without money are, as in immigration cases, often the most in need, given poverty and language barriers. Third, there are economic sanctions for advancing arguments in a context where the Attorney General has been told to go after lawyers. Finally, note there are other issues in the orders that are outside this program, such as employment issues. And one last rule that comes in various forms, from some state professional bar organizations, touches on the role of lawyers in representing the unpopular. Here we have Rule 1.2b that says, quote, "A lawyer's representation of a client, including representation by appointment, does not constitute an endorsement of the client's political, economic, social, or moral views or activities." Now, the purpose of this rule is to avoid discouraging lawyers from representing clients who are unpopular or whose views are controversial. The official comments further explain as follows. Legal representation should not be denied to people whose cause is controversial or the subject of popular disapproval. By the same token, representing a client does not constitute approval of the client's views or activities. We could call this the John Adams rule of ethics. And California's comments to its Rule 1.2 also echo this, saying, quote, "A lawyer's representation of a client, including representation by appointment, does not constitute an endorsement of the client's political, economic, social, or moral views or activities." End quote. So what ethics rules does all this funnel us into? First, the duty of competence and diligent advocacy for law firms and lawyers at issue. Second, it raises ethics-centered conflict of interest issues. Third, it intersects with ethics rules relating to pursuing claims without a non-frivolous basis in law or fact. And this is a two-way street rule for both private lawyers, but also government lawyers risking making charges against other lawyers improperly. So let's now turn to the first ethics rule to get a recap of the governing ethics rules that relate to zealous advocacy. Here we look at the duty of diligent advocacy in pressing claims. California Rule 1.3 says, "A lawyer shall not intentionally, repeatedly, recklessly, or with gross negligence fail to act with reasonable diligence in representing a client." For purposes of this rule, Reasonable diligence shall mean that a lawyer acts with commitment and dedication to the interests of the client and does not neglect or disregard or unduly delay a legal matter entrusted to the lawyer. Note, the old rules used zealous advocacy, but the modern move is to diligent advocacy. This comes from the ABA Model Rule 1.3, and here are its comments. A lawyer must also act with commitment and dedication to the interests of the client and with zeal and advocacy upon the client's behalf. A lawyer is not bound, however, to press for every advantage that might be realized for a client. For example, a lawyer may have authority to exercise professional discretion in determining the means by which a matter should be pursued. The lawyer's duty to act with reasonable diligence does not require the use of offensive tactics or preclude the treating of all persons involved in the legal process with courtesy and respect. And this is our twin ethics duty at issue, the duty related to meritorious claims. It is similar across jurisdictions, so we have a few here for you. California Rule 3.1 says, a lawyer shall not 1. Bring or continue an action, conduct a defense, assert a position in litigation, or take an appeal without probable cause, and for the purpose of harassing or maliciously injuring any person, or 2. Present a claim or defense in litigation that is not warranted under existing law, unless it can be supported by a good faith argument for an extension, modification, or reversal of existing law. New York's 3.1 is similar and defines the issue based on banning frivolity, where that is defined as, quote, the lawyer knowingly advances a claim or defense that is unwarranted under existing law, except that the lawyer may advance such claim or defense if it can be supported by good faith argument for an extension, modification, or reversal of existing law, end quote. The related aspect to this is the duty of candor with the court. Here we have Rule 3.3. A lawyer shall not, 1. Knowingly make a false statement of fact or law to a tribunal or fail to correct a false statement of material fact or law previously made to the tribunal by the lawyer. 2. Fail to disclose to the tribunal legal authority in the controlling jurisdiction known to the lawyer to be directly adverse to the position of the client and not disclosed by opposing counsel, or knowingly misquote to a tribunal the language of a book, statute, decision, or other authority, or 3. Offer evidence that the lawyer knows to be false. Let's thus summarize these rules before we explore their intersection with the executive orders. Together, these ethics rules require ethical candor to a court by not making false fact or law statements, all in the context of cases that are brought for a proper purpose on probable cause under existing law or a good faith argument for an extension of existing law. And if a lawyer is in such a case, then he or she has a duty to advocate with reasonable diligence, what we used to call zealous advocacy. These ethics rules are part of the framework of an independent bar, an independent set of lawyers who by enforceable ethics guidelines must operate fully, honestly, and forcefully to their client and to courts. So let's now address some of the ethics arguments that flow from the executive orders and the risks those orders have to these ethics rules and the functioning independent bar. First, lawyers may feel chilled in being too focused for their clients, or even making certain arguments if it may encumber executive anger at them and subsequent economic risk to the business. This risk of personal financial ruin for representing those unpopular chills potentially representing them, or if one is representing them, from complying with those ethics rules we looked at. The theory is this: too much diligence may anger the executive and lead to scrutiny on the law firm or lawyer personally. Think this example. You prevail in a federal immigration appeal and want to ask for fees taxed against the government under the Equal Access to Justice Act, which can allow those requests in some circumstances. Would you make that motion for your client or let it go because the additional act of trying to tax the Treasury may raise flags about you? This is one example of how the orders arguably squeeze in on those ethics rules. Second, if a noose is tightened around the idea of good faith arguments for extensions of law, then lawyers may be chilled in zealous advocacy for clients. Here is a key practical question. For example, if the Supreme Court has held X and you want it reversed, how do you make arguments against X when the law is X? The Supreme Court, of course, reverses itself on issues. For example, Roe and Bowers are two famous recent examples, both cases that the Supreme Court fully reversed within decades. So, what defines a good faith argument when the same argument is pressed in a different era? If pressure is brought to bear on firms for making such arguments, then the ethics rule about proceeding with critical diligence is pressed on its edges too. Our third area to look at here is with respect to immigration pro bono lawyers, which may be chilled in advancing new arguments in good faith, as required by the original rule we assessed, because of having to defend financial charge claims for aggressive advocacy per the executive order. For example, the asylum laws protect certain social groups from removal if one suffered persecution on account of being in that group. But how do you argue a new group not before ruled on as a social group is in fact a social group when no law says it is? It is a new argument to extend the concept of social group. But is that going to trigger the order to go after and look into lawyers pressing aggressive claims? If sanctions or even a threat of sanctions can follow for doing it and losing, lawyers will not try, or they will be chilled at the margins from trying. And again, we are then having these ethics rules pressed on their edges to narrow the concept of diligent advocacy. Here is a counterfactual to consider. For many years, gay and lesbians were not defined as a social group within asylum laws. But it is trying by lawyers in their zealous, diligent advocacy that led the concept of social group to eventually include such groups in protection. Pressure on that advocacy effort, ex ante by sanctions, risks, or threats, may well have chilled lawyers from pursuing such claims for clients, leading to no such holding or even a drastically delayed holding. We can think about this issue of ethics creep onto the advocacy principles that flow from the ethics rules with this hypothetical of recent vintage. In 1986, in Bowers v. Hardwick, the Supreme Court held that there is no constitutional fundamental right to engage in private homosexual activity, and so state sodomy laws were upheld. But in 2003, in Lawrence v. Texas, the Supreme Court held that Bowers was wrong, and there is in fact a constitutional right to engage in private consensual sexual activity in one's home. And so now, the state sodomy laws fell as being unconstitutional. Now, the arguments were basically the same in each outing, so the question then is whether the second time out, is it a good faith exercise to start a case in the trial courts and argue that the arguments rejected the first time should be adopted the second time? It was not in fact a bad faith exercise, nor was it a violation of the ethics rules, of course, but under tighter rules vis-a-vis government pressing law firms to sanction them for making arguments not warranted by law. Fact patterns like this could give rise to charges of frivolity, which chills ex ante even bringing such claims. You could repeat this idea across Roe or any other of the major decisions that are always under attack for change. And note, these examples cut both ways on the underlying politics of the cases, so it is a question of ensuring the ethics rules keep a level playing field for all. Now, there is a possible boomerang to the executive orders too. So this is not just a one-way street about attacks on the private bar. If government lawyers at the behest of their clients are pushed to take positions that are lacking in factual or legal candor under those ethics rules, or to make misrepresentations to tribunals that trip the ethics rules, then the executive orders risk being a boomerang that comes back on government lawyers. And this is also a dimension to the importance of an independent bar. It is not just the private bar, but also includes necessarily all government lawyers giving advice to their clients who are part of the bar, the independent bar. This brings us to this ethics sidebar on the government lawyer whistleblower who has made press waves in 2025 after he represented the administration originally in travel ban issues back in the first President Trump administration. And in the second term, he represented the executive on the deportation orders of alleged Venezuelan gang members to El Salvador. The lawyer said to the court that one of them was deported in error. He was later fired. He then filed a whistleblower claim. The facts are evolving, of course, but here is what has been claimed publicly at least. He claims that government officials said to ignore the district court orders. Until it is adjudicated factually and legally, we do not know the exact answer to this factual claim, but we can use it as a hypothetical. He is saying in this hypothetical, We can build off the scant public facts that we have, that the lawyer duty of candor and honesty was risked by government action. On the other side, the Attorney General says he was fired because he had that duty to represent diligently, and he did not push properly or hard enough on the claims the administration wanted to mount. This is a good little sidebar because it, sadly in irony I suppose, highlights these ethical duties and how they can tangle in the context of executive action, based here on other executive orders. But now, let us return to our next ethics rule that intersects with the executive orders we are addressing in this program. Now we go to our next major ethics rule that intersects with our executive orders against lawyers. And this brings us to conflicts of interest rules. They are similar across jurisdictions and from the ABA, so here's the basic rule. Ethics rules prohibit an attorney from representing a client when there is a significant risk that representation will be materially limited by the lawyer's responsibilities to a third person or by the lawyer's own interests. We cognize this as an undivided duty of loyalty to the client, which requires also independent judgment to fulfill. Now, informed written consent can be secured, but that is no panacea, as questions can always be raised later by the client, regardless of how factually meritless they are, about the scope of the informed consent and whether enough information was shared to fully inform, and then this can be used to create problems for the lawyer. Here is what the California State Bar says at its notes to Rule 1.7. A directly adverse conflict can arise in a number of ways. For example, when 1. A lawyer accepts representation of more than one client in a matter in which the interests of the clients actually conflict. 2. A lawyer, while representing a client, accepts in another matter the representation of a person who, in the first matter, is directly adverse to the lawyer's client. Or 3. A lawyer accepts representation of a person in a matter in which an opposing party is a client of the lawyer or the lawyer's law firm. In one case, called State Farm Mutual Automobile Insurance Company versus Federal Insurance Company from 1999, the reporter citation is here for you, the court held that this ethics rule was violated when a lawyer, retained by an insurer to defend one suit, and while that suit was still pending, filed a direct action against the same insurer in an unrelated action without securing the insurer's consent. You can see the additional wrinkle here too, as that case involved State Farm complaining. But the other client, the plaintiff in the direct action, may have also complained that he or she did not get proper notices, all of which conflict notices trigger the first ethics rules we looked at also, to zealously represent one client. The question is, would you zealously represent one client properly when the defendant is also your client in an unrelated matter? Now let's see how these executive orders touch this ethics rule. In one context of reported settlements, firms agreed to give large amounts of pro bono efforts to the executive. But agreeing to provide pro bono services to the executive for its causes may impact obligations to other clients. For example, if law firms are doing pro bono work for the executive to help deport people, can they also represent people being deported? Do we have the State Farm problem we just looked at? And again, disclosures may be required, but some of these conflicts may not be okay to waive, which creates more ethics traps on the conflict of interest rules. On the waiver issue, also, here is what California law has said in the ethics notes to Rule 1.7. There are some matters in which the conflicts are such that even informed written consent may not suffice to permit representation. It also, again, creates a strong incentive to not antagonize the executive, and that impacts existing clients who may need to fight the executive aggressively on laws, regulations, rules, and the like. How does a firm challenge a government tax rule, for example, when the same government is attacking the law firms or holding settlements with the law firms that have executory obligations on the firms? Here is a case of where ethics conflicts simply cannot be waived no matter what, and it's a strange fact pattern to say the least. In the middle of one Mr. Fulton's trial for conspiracy to possess and import heroin, the government informed the court that the government witness on the stand previously stated that he had once imported heroin for Mr. Fulton's trial counsel. He was convicted and sought relief based on ineffective assistance of counsel, given the conflict of interest that appeared that he argued was simply not able to be waived. Our ethics rules matter here as follows. A situation in which the attorney's own interests diverge from those of the client presents a core ethics problem. Specifically, the attorney's fealty to the client is compromised. How does the lawyer cross-examine the witness if it exposes himself to problems? Here is what the federal court held. Given the breadth and depth of this kind of conflict, we are unable to see how a meaningful waiver can be obtained. The conflict here involves a bias arising out of counsel's powerful self-interest in avoiding criminal charges or reputational damage. That is at page 613 of the cited opinion. This is an example, albeit unique and odd, of where financial or even reputational damage, aside from criminal liability, from one representation may well mute a lawyer's ability to zealously represent his client. This matters to our discussion today because it shows those types of extrajudicial interest, such as reputation or personal well-being, if at issue, may create a conflict that cannot be discharged. This ethics situation led the California State Bar to issue this statement in May 2025, noting several points of ethics that centrally go to the issue of ethics of an independent bar. First, attorneys have an ethical duty to provide competent and diligent representation to clients, regardless of how unpopular or controversial their causes may be. Second, attorneys must exercise independent professional judgment, free from external pressures or influences that might compromise their representation. Third, attorneys must not reject, based on personal considerations, the cause of the defenseless or oppressed. Fourth, all attorneys swear an oath to uphold the United States and California constitutions, and to faithfully discharge the duties of an attorney to the best of their knowledge and ability. Fifth, in both the federal and state legal systems, courts determine the meaning of the law, and all attorneys, including those in other branches of the government, have an obligation to comply with court orders. Sixth, when any action, regardless of its source, discourages or penalizes attorneys for representing certain clients or causes, it raises serious concerns about the ability of the legal profession to fulfill its obligations. And here is the key conclusion. Quote, "The independence of the legal profession is a cornerstone of our justice system. Recent actions of the current federal administration's executive branch threaten these core principles." End quote. So as we've seen, our ethics rules that we may primarily think of as regulations on us as lawyers by our state bars and judges actually intertwine to form a mosaic that paints a picture of the ethical touchstone for an independent bar. This conflux of multiple ethics rules also has a constitutional guarantee, in criminal cases and other contexts, of effective assistance of counsel. That also points to the key role of an independent bar, able to represent zealously subject to ancient guardrails of Section 1927 sanctions, inherent power to sanction, Rule 11, state analogs, and state bar rules. What are the pillars, then, ethically speaking, of the independent bar? Diligent or zealous representation. To advance new arguments under existing law or good faith advancements for the law. To not advise on law breaking. To make no false factual or legal statements to a tribunal. There is also an importance of self-regulation by our state bar organizations to discipline lawyers, because it removes government from dominating the profession, along with other rules such as no fee sharing with non-lawyers, which also serves the same goal of an independent bar. This matters in our ethics rules because an independent lawyer is able to represent anyone, executive and unpopular included, against anyone, executive and unpopular included, as a means of getting to the truth of disputes. Thus, as we have explored, an independent bar is a cornerstone to our ethics system and a means of furthering due process and the steady hand of the rule of law. It is also grounded in other bar rules and ethics principles. Here we have a few. Here is first the Model Rules Preamble and Scope from Notes 10 and 11. The legal profession is largely self-governing. Although other professions also have been granted powers of self-government, the legal profession is unique in this respect because of the close relationship between the profession and the processes of government and law enforcement. This connection is manifested in the fact that ultimate authority over the legal profession is vested largely in the courts. Self-regulation also helps maintain the legal profession's independence from government domination. An independent legal profession is an important force in preserving government under law, for abuse of legal authority is more readily challenged by a profession whose members are not dependent on government for the right to practice. And as articulated by California's preamble purpose. The following rules are intended to regulate professional conduct of lawyers through discipline. They have been adopted by the Board of Trustees of the State Bar of California and approved by the Supreme Court of California, pursuant to code to protect the public, the courts, and the legal profession, protect the integrity of the legal system, and promote the administration of justice and confidence in the legal profession. Florida has also articulated similar ideas. This comes from the Florida Bar Journal in an article about the role of an independent bar as a centerpiece to democracy. It said, quote, "Judicial independence enriches democracy. To undermine this independence would mark a drastic departure from our nation, ripping up our federal and state constitutions and their values. We cannot allow political demagoguery and special interests to undermine the genius of our constitutional system. We must fulfill our duty to protect the independence of the bar and the judiciary." That was from the year 2000. So let us now get back to our history a bit and see how the Harry Bridges saga played out insofar as the ethics issues with lawyers under attack. Recall our lawyers there defending Bridges and other alleged communists. They were imprisoned in multiple cases representing communists by a judiciary captive to the executive. Also, they were accused themselves in court by government prosecutors of being communists to discredit them as lawyers. It all led to the Supreme Court in Bridges v. Wixon to say, quote, "The record in this case will stand forever as a monument to man's intolerance of man. Seldom, if ever, in the history of this nation has there been such a concentrated and relentless crusade to deport an individual because he dared to exercise the freedom that belongs to him as a human being, and that is guaranteed to him by the Constitution. For more than a decade, powerful economic and social forces have combined with public and private agencies to seek the deportation of Harry Bridges, who came to this country in 1920 from Australia." End quote. And as you recall, Telford Taylor was now decried as a disloyal American by Senator McCarthy, but he stayed on representing Harry Bridges. So what happened? Taylor refused to insult the government lawyers or charge them or the court with a witch hunt. It's obviously more Hollywood-like to engage in such rhetoric, but he took a different approach to his advocacy and persuasion. He argued the facts only and asked that only fair application of balanced law apply, as against the extreme rhetoric of the government. Here is his closing argument. "I would suggest that there are few things as truly important today, and that is the law shall remain the law in this country and in all courts wherever they sit, and I am aware your honor is deeply aware of that as anyone here, and it would be presumptuous of me to say much more than I have now said. I myself had some opportunity to see in Germany the remains of a society in which the judges failed the courts, a society in which the judges wrote opinions and became glued to the path of least resistance. And I will conclude by saying to your honor that a judgment for Harry Bridges in this case will not be in the deepest sense be a judgment against the government, or a judgment for Mr. Bridges, or a judgment for or against anybody touched by this controversy. It will be a judgment that the law abides here, and that's all the justification it will need." End quote. That is a plea for fair facts in a court and a balanced application of the law, without engaging in hyperbolic activity that tripped ethics lines. It was, in my opinion, the epitome of a lawyer-statesman staying balanced and honest and seeking only a day in court on the facts and law. Nothing more, nothing less. And he won the case, ending the remarkable 20-year saga. Let's double-click now on present day and some of the settlements as reported and the ethics issues involved. Reported settlements include pro bono work for the executive. But what about existing clients with adverse interests? If representing pro bono asylum seekers, can you also represent the executive in crafting policies or litigation against those people? Will firms prioritize economic survival of the firm ahead of zealous defense of other clients? For example, not do things needed for clients or arguably needed to antagonize the executive? Interestingly, here is a federal law. 18 U.S.C. Section 201b1 makes it illegal to offer or promise any public official to give anything of value to any other person or entity with intent to influence any official act. End quote. Is giving millions of legal services in return for avoiding punishment under an order of violation? It is not clear, but this is a curious question raised by the fact pattern that itself implicates another ethics quagmire. Now, not all firms settled, and the litigation by some firms over the orders has resulted in district court opinions striking down the executive orders. And while the arguments were on myriad grounds, they did touch on some of our ethics issues. You have the order cited there if you want to go read it, but here is a thumbnail relevant to this ethics inquiry. The law establishes that advocacy by attorneys to the courts falls within the category of private speech protected by the First Amendment. That ties to our issue of the role of an independent bar. It goes on to say, quote, "Of course, plaintiff is a business of attorneys, at least some of whom litigate. And in the normal course of litigation, those attorneys necessarily engage in advocacy, satisfying the first requirement for constitutional protection. This advocacy is on behalf of plaintiff's clients, who also have a fundamental First Amendment right in speaking and associating with counsel." End quote. Further, an inability to deal with government means criminal defense lawyers at the firm cannot represent their client by communicating with prosecutors, damaging their obligation to provide effective assistance of counsel. Finally, the ethics rules may require the firm to withdraw from lots of relationships because of the burdens of executive order, or to be limited in ability to properly represent and advocate for clients. In the cases, there was also expert testimony from an ethics professor on the ethics issues involved. So although only cited briefly in the opinion, those ethics opinions are certainly important for our program today, so I want to highlight them a bit. This is from Professor Simon, the Distinguished Professor of Legal Ethics Emeritus from Hofstra Law School. He said as follows: "If the executive order is permitted to stand, it will have the consequences set out below, all of which will undermine and threaten the fundamental principles of our system of justice. First, law firms will be less likely to agree to represent clients that the president or his allies and supporters or future presidents view with disfavor, and lawyers will be less likely to agree to represent clients who are unpopular with the president's base. Second, law firms will be less likely to make legal arguments challenging a president's actions, policies, or orders, or the actions, policies, or orders of others in the executive branch. Third, law firms will hesitate to make arguments inconsistent with the announced or anticipated positions of the president or of allies or supporters of the president outside of government. Fourth, clients are likely to have a narrower choice of counsel and greater difficulty finding counsel. And fifth, clients will be less likely to bring legal challenges to actions taken by the president or by his personal or political allies, supporters, and friends inside and outside of government. His analysis is heavily grounded in all the ethics rules we already went through today, so this is an interesting application of our ethics rules to the orders in the context of litigation. One final note. We have discussed the ethics issues, but we also have judges deciding these cases. So let's do a quick ethics refresh on the ethics canons that dictate their approach to cases raising these very ethics questions. Quote, "An independent and honorable judiciary is indispensable to justice. In our society, a judge should maintain and enforce high standards of conduct and should personally observe those standards so that the integrity and independence of the judiciary may be preserved." End quote. This is the ethics framing principle that then governs the interpretation and application of other ethics canons. Now, canon number 2, 2A, these are the ones to keep in mind. The judge must act at all times in a manner that promotes public confidence in the integrity and impartiality of the judiciary, and must avoid impropriety and the appearance of impropriety in all activities. And avoiding even the appearance of impropriety is critical, as it is not just did you do something wrong or not. You may have done nothing wrong, but it could still be seen as improper, and so that means even if there is no wrongdoing, A judge should be cautious and step aside in certain cases to preserve public confidence. As we move to the next slide, let's take a look here at Canon 3. This involves the idea that the duties of the judicial office take precedence over all other activities. The judge must perform those duties with respect for others and should not engage in behavior that's harassing, abusive, prejudicial, or biased. So, for example, a judge should be faithful to and maintain professional competence in the law. He or she should not be swayed by partisan interests, public clamor, fear of criticism, and the like. A judge should hear and decide matters assigned, and should maintain order and decorum in all proceedings before the judge. Now let's go to Canon 4. And Canon 4 on our slide, you can see here, talks about how a judge may engage in extrajudicial activities, civic, charitable, education, religious, social, or financial type activities, of course. And of course, a judge can speak and lecture on the law and even non-law related subjects. But what's the big picture ethics principle? Here it is that a judge shouldn't participate in these activities if it detracts from the dignity of the judge's office, or interferes with the judge's official duties, or if it reflects adversely on the judge's impartiality. So that line can be hazy at times, and the fundamental point I think that we can distill from this canon, and several of them as they tie together like DNA helix strands, is that a judge should not engage in conduct that gives the impression that the judge may lack partiality on certain issues or may favor certain people. This is the other side of our ethics coin, so that we have an independent judiciary operating to adjudicate disputes brought by independent lawyers and an independent bar. Now I think before we conclude, this penultimate point matters. We have ethics rules for the bench and bar because each must be independent. We always discuss in our legal culture the importance of an independent bench. But these executive orders, aside from anything else you may think of them, have given us the chance to really address the key important factor for us as lawyers of what an independent bar means from an ethics viewpoint to our system of justice. And this ethics-based idea of an independent bar is not something our legal culture talks about a lot. But we have been able to explore the ethics rules that work together to establish the ethics-based touchstone for an independent bar, and we saw the damage when the bar is pressured in the Harry Bridges case, which was a subplot to my book, but part of the mosaic of the story of those remarkable trials. And if you want to learn more about it, you can of course get the book, or better yet, you can get more education credit by watching another couple of programs I have done on the book, a 2-part series called Persecution by Prosecution. We spent time today on multiple ethics rules touched by executive orders against lawyers. These ethics rules we addressed include the duty to advance meritorious claims, to do so diligently or zealously, to do so honestly, to not have conflicts of interest, and the duty of loyalty and independent judgment. And we looked at the rules that relate to distancing lawyers from their clients, so as to ensure the unpopular secure lawyers too, what we called the John Adams rule. And this took us back to the earliest days of the Republic, when John Adams represented that time's most hated characters, because of his belief in due process and fairness, a sentiment that has animated our ethics rules ever since. Of course, an independent judiciary is well discussed, but an independent bar stemming from our ethics rules is also a key to proper lawyering for the legal system, and it is all these ethics rules that we looked at today that help define the ethical touchstone for an independent bar. Our ethics rules we considered today all tie together to form part of the picture of the ethics grounding for an independent bar. Thus, as we explored the current executive orders, we saw that the orders push against the ethics rules designed to guarantee that independent bar. The orders risk chilling lawyers and law firms in advancing diligent or new and novel claims on behalf of their clients, given the risk of upsetting the executive in these cases. We saw ultimately how the John Adams rule that we discussed, the rule and experience that in part birthed our legal profession's animating principle of diligent and zealous representation of all, is pressured by orders aimed at sanctioning lawyers who represent those disfavored or unpopular in this moment of history. We also looked at the Cold War Harry Bridges lessons, and the damage to proper lawyering in that moment with attacks on lawyers, all of which has important stories for today as we trace the history from John Adams to the Cold War to today. And we addressed the fact that the ethics rules apply to government lawyers too, so boomerang risks exist for all in crossing the ethics rules. Finally, remember the fact that not all conflicts can be waived. We saw the case of the lawyer and the heroin importer defendant, and how reputational damage to the lawyer was enough to trigger an impossible situation, and how as a result, the orders are creating risks for firms as it relates to their role representing other clients too. In short, we saw the ethics quagmire that now exists for law firms facing executive orders that touch their practices. Thank you for watching this ethics program today. As always, please reach out with any questions, stay curious about the law, and I look forward to future programs. Thank you.